votes, Craig versus Boren, Weinberger versus Weisenfeld, and others. Crucial to her approach was the principle that not only rules that discriminate against women, but also ones that appear to treat women better than men are bad for women, bad for all of us. A notion, I need to say, was not as obvious then as it is to many of us today. In 1974, Justice Ginsburg, with two co-authors, one of them Herma Hill Kay, I believe a personal friend of Justice Ginsburg, who was also my most important law school mentor at Berkeley, published the first law school casebook in the field of sex discrimination. I was in the first class with Professor Kay, which she taught from that book, a book that pioneered the field and made us all feel like pioneers as well. It was a terrific honor for me to touch this history, which Justice Ginsburg, long before she was a justice, was so important in making. All the more so because almost 20 years later, after I took this formative course, I was to publish my own casebook on gender in law, which this summer I hope to move ahead to its 4th edition. Based on her important role in shaping the law of sex discrimination and her work as an equal rights advocate and scholar, which we will hear more about today, it is fair to say that Justice Ginsburg would be an appropriate honored guest for our Great Lives in the Law series, even if she had never become a Supreme Court justice. Because of the particular area of law in which she has made her mark, I am especially thrilled to welcome Justice Ginsburg to Duke. Our program today is an interview with Walter Dellinger, Douglas Maggs, Professor of Law at Duke, former Assistant Attorney General in charge of the Office of Legal Counsel and Acting Solicitor General, and now partner and head of the appellate practice at O'Melveny & Myers in D.C. Professor Dellinger is one of the foremost Supreme Court advocates, having personally argued or written the briefs in dozens of U.S. Supreme Court cases. Professor Dellinger, Justice Ginsburg.
Thank you. Welcome to Duke. You were born in 1933, which was the heart of the Depression, to Nathan and Celia Bader. What was the Depression like for your family in Brooklyn?
I was born in the height of the Depression, but I lived through the years when the economy was improving. People lost their life savings in the Depression. There was no Federal Deposit Insurance Corporation. That had a lasting effect on my mother in two ways. One, she never bought anything on credit. And two, she saved the money that I used to go to college. She had $10,000 spread out in 5 bank accounts, because even though there was FDIC insurance, she didn't quite trust it.
What did you learn from your mother?
I learned to love to read and to be independent. My mother told me 2 things constantly. One was to be a lady, and the other was to be independent. Now, the latter was something most unusual for those times, because for most girls growing up in the 40s, the most important degree was not your BA, but your MRS. Mm-hmm. You were to find Prince Charming and live happily ever after. My mother certainly thought it would be fine if I married, but she said it was most important for me to be able to carry my own load, to get a job and support myself. And be a lady meant don't react to life situations in anger. Don't consume any of your time on such emotions as envy, because they just sap energy and have no productive value. So it was to react calmly and not let things hurt you. Those were the main things.
She must have been really proud of what a wonderful student you were in high school and college.
Well, sadly, she died when I was 17, so she died the day before my high school graduation.
Well, she missed some wonderful years, but she'd be proud of them. Cornell must have been, except for the sadness over that, Cornell must have been good years for you, the 4 years at Cornell.
For the most part, yes. Cornell is an incredibly beautiful school. It had a very fine faculty, but there was a ratio. There were 4 men to every woman. At the time, we thought that was just great. But in retrospect, it was an out-and-out adverse quota system. Mm-hmm. So the girls in my class were ever so much smarter than the boys.
I think you managed to locate the exception to that rule, didn't you?
I think so. That my life partner, we met when I was 17 in my first year at Cornell, and he was 18 in his second year. And we have survived together now for over 50 years. If you ask Marty, my husband, he'll say 50 years and it seems longer.
Yeah. The unusual choice you made came right at that critical point where you decided to go to law school. What year would you enter law school?
I started law school in 1956.
Right. So there were 9 women and 500 men in the class. What is it? Was that a hard choice to be one of the 9 women who chose to go to what was certainly considered a male occupation at the time? Was that a tough decision? Did it come naturally to you?
A tough decision on my part to be a lawyer?
To be a lawyer, against the gender stereotype that obviously is obvious from the numbers at Harvard Law School at the time, and all other law schools, I mean. So.
Well, my choice was made easy because I married Marty in 1954, and I had 2 years out before I started law school. My family, my father, thought it was fine for me to be a lawyer because if I failed, if I couldn't get a job, I had a husband who could support me. To be one of 9 at Harvard Law School in those ancient days was a big advance because Marty's class, 1 year ahead of my class, had only 5. So.
Was the atmosphere, what did you feel like the atmosphere was like for that handful of women?
Insensitive. And I'll explain what I thought was the major problem. And it was simply this. Law school classes were in 2 buildings, Langdale and Austin Hall. But there was only 1 women's bathroom. So think of yourself taking a law school exam in Langdale and having to make a mad dash to Austin and get back in time to finish that heavily time-pressured examination. Some of the professors had ladies' days. Mine never did.
Where they called on women exclusively.
Women, you called on women
day for
that day and never in the rest of the term. But the one thing that you felt, well, years later when I was teaching at the Columbia Law School, one of my colleagues, this is in the early 70s, complained, and he said, in the good old days, if the class is moving slowly and you wanted to move it along, the thing to do was call on the woman. She always was well prepared, and she had a crisp, right answer that would take you to the next step in the class development. Nowadays, he said, there's no difference. The women are as unprepared as the men. So that was the idea was, if you stumbled in your answer, you were failing not only for yourself, but for your entire sex.
You finished at the top of your class at Harvard Law School, finishing at Columbia for your last year when you all went down to New York. So 2 years at Harvard, 1 year at Columbia. Top of your class at both places. Law review, the only person probably to have been on the law review at both Harvard and Columbia Law Schools, clerked for a very distinguished judge on the Southern District of New York. What did you consider doing in terms of professional opportunities? I mean, you wound up going to Rutgers, but did you think about practice? Did you think about, what did the world of law look like to you when you were finishing a clerkship?
Better than it did when I graduated, because when I graduated, no firm in the entire city of New York gave me a job offer. And that was very distressing because I hadn't encountered out and out discrimination in law school. But there were so many firms in those days that were upfront about it. There was no Title VII on the books, no anti-discrimination law. So they would say, well, we don't want women, don't have any women among the people who interview for our firm. When I
They
finished,
tell the law school.
yeah,
we
yeah.
only want to interview
And
men.
then the law school accepted that without question, and so did the women. Then after a clerkship that ran 2 years, and a judge who was able to tell legal employers, she's okay when I need her, she will come in even on weekends, and her daughter is not a serious distraction. Then I had offers from a number of firms, including one with which my husband has an affiliation today, the Fried Frank firm. But then I had the chance to work on Columbia Law School's International Procedure Project. I did that for 2 years. And there was an offer from Rutgers Law School to teach procedure, which is my favorite subject.
Right.
I had wanted to be with a firm for some years before ending up in teaching. Teaching was my goal, but it wasn't an immediate one. Still, I looked around the country, and there were less than 20 women teaching at law faculties from the East Coast to the West Coast. So here was a burden in hand, and if I didn't take it, an offer might never come again. And so that's how I began my teaching career.
Then there is what I think is a very critical passage in your life, one that leads to what Dean Bartlett was referring to when she said yours would be a great life in the law if you'd never been appointed to the Supreme Court. In that early period at Rutgers and when you joined the faculty at Columbia, the field of gender discrimination literally did not exist. And there was a transition from your dominant interest in procedure, including international procedure, that took you to be the executive director of the ACLU's project on women and the law. It was a transformation that led to your 6 Supreme Court arguments in the 1970s that shaped the law. And I want to then take you back to when you first, I think our students don't really have a sense of how accepted gender discrimination was as part of the framework. That is where the Supreme Court was. For example, when you were in law school, there were, not only were there no sex discrimination courses, it didn't exist as part of the constitutional law curriculum except a case like Gossard against Cleary from the Michigan bartender case of 1948, where the court upheld a ban on women being bartenders unless they were the wife or daughter of the male owner. How was a case like that presented when you were in law school? What was your reaction to it?
It was in the constitutional law casebook, Gossett against Cleary, as a little squib. This was a law by the state of Michigan that, as you said, prohibited women from serving as bartenders unless their father or husband owned the establishment. Interestingly, they could serve as waitresses at the tables, but they couldn't be behind the bar where they would have a little more protection against the rough and tough types. In any case, Gossett was a woman who owned a tavern, and daughter was the bartender. This was presented to us as an example of economic and social legislation. The idea was women were being protected against the drunks who might inhabit taverns, and that the argument that this is an interference with the liberty of the women to do what they wish to do in life, that argument was put down. The court said, this is economic and social legislation. It's presented to us as preserving women's strength and health, and we are not going to second guess it. It was one of many cases in which the Supreme Court was lightening or loosening its grip on state legislation. It had been, for a period, declaring any economic and social legislation unconstitutional. For example, the child labor law, unconstitutional because it interfered with freedom of contract. In any case, Gossett was given as an example of the Supreme Court's retreat from the stranglehold on state economic and social legislation. What none of us paid any attention to was his mother and daughter that were being literally put out of business, and that the real motivating force behind that legislation was the bartenders union. Mm-hmm. So Gossett was one of the cases that needed to be rethought in the 70s, one of the ones that had to be overturned.
What led you to begin to think that it was not anything that struck you or any of your classmates really at the time you would have said. What happened, what led you in that period when you were doing international procedure? I guess you went to Sweden for a summer, you came back, it's the beginning of the 70s. What led you to take on this fight and make you see the world in a different way?
I never thought about it seriously. I thought the discrimination against women came with the territory, and I just had to endure it. I began thinking differently when I was in Sweden in the summers of '62 and '63. And what helped change my thinking was a woman named Eva Moberg, who was writing a column in the Stockholm Daily Paper, and the gist of it was, why should the woman have 2 jobs and the man only 1? Sweden was ahead of the United States at that point. It was well accepted that there should be 2 earners, perhaps because they had rather steep inflation, but the woman was also expected to take the children for the dental checkups, buy the new shoes, have dinner on the table at 7. And there was much discussion among women about this approach that it wasn't enough that he took out the garbage. And some women reacted, well, I can do everything. This is the queen bee type. I don't need him to do anything around the house. I can be a doctor, lawyer, and still take care of all the rest. And others said, that's right. And besides, it will be much healthier for children to grow up with 2 caring parents, not just 1. So I began to think about it then. And I was also influenced by Simone de Beauvoir's book, The Second Sex, which was written in the 40s. Those were both eye-openers for me. But I came back home and didn't seem that I could put that awakening to any practical use until the end of the 60s. That was, the 60s was the great civil rights movement, and some people began to think about gender discrimination. I had pressure from 2 points. One, my students, they wanted a course in women in the law. And to satisfy that interest, I went to the library. In the space of 1 month, I read every federal decision that had ever been written in the area of gender in the law, every law review article, and this, I must tell you, was no mean feat at all because it was barely anything. There was less than would be produced inside of 2 months nowadays. The other was that women began to complain. Women came into the American Civil Liberties Union New Jersey office and complained about, well, the typical case in that time were women who were teaching school and were told that they had to go on maternity leave 3 months, 4 months, 5 months after their pregnancy started. Now, maternity leave was a euphemism. You didn't get paid for that leave, and you didn't have any right of return unless the school wanted you back. And these women said, we're very well equipped to do our job, and there's no reason why we should be taken out of the classroom. So that's, the ACLU in New Jersey turned to me. I was the woman and on the faculty, and I taught procedures. So those were the cases we started with, or others involved such things as health insurance. Most employers in those days would not give women insurance that covered their families. They could get single-person health insurance, but family coverage was only for a man. And some women who worked for employers that had more advantageous health benefits wanted to qualify as for family coverage and couldn't. So it was that kind of complaint.
The law at the time you started, again, I think it's hard to grasp for students these days. The law was so unfavorable. It wasn't just unfavorable, it was diametrically opposed. It was assumed that distinctions based on gender were obviously reasonable. Take a case like Hoyt versus Florida, decided even after you finished law school in 1961, where the Warren Court, thought to be a liberal progressive institution, in 1961 holds that women can be excluded from jury service unless they go to the trouble to make a special application, and indeed that a woman on trial for the murder of her husband, who had been extremely abusive, has an all-male jury because women are excused unless, or precluded unless they can show they can overcome their, quote, special responsibilities as women. So this is an extremely unfavorable terrain.
Well, the Supreme Court thought it was most favorable. I mean, the way they approached Hoyt against Florida, they said, what are the women complaining about? They have the best of both worlds. They can go and sign up and serve if they want to serve. But if they don't want to serve, they are relieved of that obligation. And the notion that being a full citizen includes obligations as well as rights was something that was very strange.
You obviously had a strategy in the 70s about where you wanted to get to with these cases. And part of the decision was to take cases that were ostensibly about discrimination against men. Again, it may seem like an obvious choice to us today, but that was not obvious or uncontroversial at the time. Tell me a little bit about your strategy of where you wanted to get the law.
The strategy was to go after gender stereotypes and to rid the law books in the states and in the nation of these arbitrary lines that separated the world into two spheres: the world outside the home, which belonged to the man, and the world within the home that was women's province. So, in fact, the first endeavor was to try to get to the Supreme Court, one case involving a stereotype that immediately impacted adversely on a man and the other on a woman. Well, it's hard to plan cases so that they arrive in the court at the same time, as you as a litigator know very well. But our lead case was Reed v. Reed, Sally Reed, whose son died tragically. In fact, he had killed himself with his father's rifle. And she wanted to be appointed administrator of his estate. Her divorced husband applied for somewhat later, and the court said, well, the law resolves my choice. The statute read, as between persons equally entitled to administer a decedent's estate, males must be preferred to females. Now, that was just the perfect case to be the turning point. Paired with that was the case of Charles E. Moritz, who encountered gender discrimination in, of all places, the Internal Revenue Code. And it worked like this. There was, in those days, a dependent care deduction for a child under the age of 12 or a family member in your care who was disabled. In Charles Moritz's case, it was his 93-year-old mother. He was a bookseller, and during the day when he was away from the home, he hired a housekeeper, nurse, to take care of his mother. And he took the deduction that was allowed. And he was told he didn't qualify because the law said the deduction was available to any woman or a widowed or divorced man. Congress was thinking about people who might have the care of children. So it could be any woman, but not a man unless he was widowed or divorced. So here was Charles Moritz saying, I don't understand this law. A dutiful daughter would get the deduction. Why not a dutiful son? And we thought if those cases could get to the Supreme Court at the same time, the learning curve would advance significantly on it. But as it turned out, it took the 10th Circuit 18 months to decide Charles E. Moritz's case. And so Reed was there alone, and it was the turning point case. And I like people to appreciate that all of those early gender discrimination cases in the 70s occurred when the Warren Court was gone, and the not so, quote, liberal Burger Court held sway. And for the Warren Court, Hoyt was the pattern. They were not going to change anything about the laws that differentiated on the basis of gender. But the Burger Court, starting in 1971 and continuing after, overturned literally dozens of federal and state laws.
I don't know if any advocate has ever been responsible for having more laws overturned than you, counting the ones that necessarily followed in the wake of each of your victories in the Supreme Court. At the same time, in the 70s, you were one of the advocates for the passage of the Equal Rights Amendment, which we all thought would pass for a while, and then the last-minute opposition came in. Now that you won with your wonderful opinion in the VMI case, would it have made a difference? Would the constitutional world be different if we had the ERA now, as compared with where you see the law?
It may not have made a difference in the specific results of cases. But it would have made an important symbolic difference in this sense. Every modern constitution, every constitution written since the end of World War II, includes a provision to the effect that men and women are citizens of equal stature. Ours does not. I have 3 granddaughters. I would like them to be able to take out their constitution, I carry mine with me always, and say, here is a basic premise of our system, that men and women are persons of equal citizenship stature. But it's not in there. There's only the Equal Protection Clause, which everyone knows was not meant in the 1860s to change anything with regard to women's status. After all, women didn't get the vote till 1920.
Any of your Supreme Court arguments stand out in your mind as the most memorable, or are they like grandchildren to be equally valued?
At the end of the last argument I made in the court, and this is the fall of 1978, it involved Missouri's jury system, which put women on the roll but gave them an exemption for the asking, and if they didn't return the jury form, it would be assumed they didn't want to serve. Anyway, the name of the case was Durham against Missouri. I divided the argument with the public defender from Kansas City, so I had a precious 15 minutes, and I was satisfied that I had gotten everything essential out in that brief time. I was about to sit down when my now chief, then Justice Rehnquist, said, "And so, Mrs. Ginsburg, you won't settle for Susan B. Anthony's coin, a face on the new dollar coin." And that, the contrast between that 1978, and I couldn't think of something fast enough like that. You know, you always think of your best argument in the car going back. So mine would have been, no, Your Honor, tokens won't do.
Oh, I hate that.
But in any event, this chief, we go fast forward to 1993, and he's going to preside at my swearing in. Janet Reno, our Attorney General, is going to present the commission. Attorney General Reno, as you know, Walter, did not want to be called General, as
Right.
is the tradition. She wanted to be called Ms. Reno. The chief wanted to be sure that he could say Ms. comfortably. So the day before, he actually repeated her name a couple of times. And that difference, his consciousness in 93 and lack of consciousness in 78, shows that, yes, we have made real progress.
It may help to have you as a colleague, I think, for the years he did. Now, just a brief word about your more than a decade on the Court of Appeals for the District of Columbia. Was that valuable to your Supreme Court service? Or if you'd spent another dozen years arguing and teaching, would it have been the same? What value do you place on it now that we're naming most of our justices from the Courts of Appeal? Do you think that's important to do or not?
The D.C. Circuit experience was incredibly valuable to me in 2 ways. When you're a law teacher, you are for the most part alone, or you may ask your colleagues for opinions on something you've written, but in the end, it's yours to decide. If you're part of a collegial bench, then you can make no decision without carrying at least one other mind. So that collegial process was important. Another is that the D.C. Circuit is really the government's court. I'd say over 70% of the cases involve the U.S. government, a government agency, a government officer on one side or the other. So we were specialists in administrative law and in constitutional law, some very important constitutional controversies that ended up in the Supreme Court were first in the D.C. Circuit. So both the substance of the law that the D.C. Circuit dealt with and this collegial process, which became ever more challenging when the bench was not 3 but 9.
Let's go to the 9-bench and collegiality then, because I know that this is you're a court that's been together longer than any court since one in the early 1800s, so you know each other very well and often say extremely harsh things about one another in print, just scathing comments, and on issues that matter, deeply divided on abortion, affirmative action, the power of the federal government, who should be president. And yet, you know, I think many people are surprised when they see a picture of you and Justice Scalia sitting on top of an elephant smiling and happy in India and wonder how you all managed to get along. So I'm going to shut up for a little while and have you talk to us about, if you would, about what interactions, personal interactions are like in the court among the justices. What's life like there?
It's by far the best place I have ever worked. There's a spirit at the court, and it's not just the justices and their staff. It just pervades the entire institution of being proud of the institution you serve and wanting to give it your best and make sure that you don't leave it in any worse shape than it was when you became part of the institution. There is an esprit that is uplifting, energizing. The relationship among the justices is, as you suggested, very close, because no matter how great our differences on what the law is or ought to be, we know, we pride the institution in which we work and know that it will suffer if we can't get on well with each other. So we have little habits that help promote that collegiality, and one is before every conference and before every morning when we take the bench, we go around the room, each justice shaking hands with every other, looking each other in the eye, and saying in effect, now even though you sent that nasty dissent around yesterday, we are all in this together, and our own egos are not what's important. We have lunch together every day that we sit and every day that we confer. And at lunch we talk about anything and everything. We might talk about the orations that we've just heard in the courtroom, including Walter Dellinger's. Or we might talk about the new opera at the Washington National Opera, the new show at the National Gallery, or even, because all of us, except for Justice Thomas, are well beyond what the French call a certain age. So we talk about not our children, but our grandchildren. And then there is a togetherness in other respects, too, social events. Our spouses meet quarterly, and they have lunch together in what was once the ladies' dining room, and is now the Natalie Cornell Rehnquist dining room.
Oh, named after the Chiefs, late
Yes, who took, even though she was battling cancer, took it as her assignment to renovate those rooms. And so Justice O'Connor thought that Natalie Cornell Rehnquist would be the perfect name for the room. And that's how we solved the ladies' dining room. any case, the spouses do have lunch together quarterly, and they divide catering responsibilities. And as you probably know, Walter, my husband is a super chef.
He is indeed a great cook.
And he's the one most in demand as co-caterer.
He was an especially appropriate person to sort of integrate the spouses' dining room with the Supreme Court, I guess, to be.
But the other thing that the spouses did is they had 2 parties celebrating our longevity. The first one was when we had been together 9 years, and at that point we were the longest sitting court since the court numbered 9. There was a longer court that sat from 1811 to 1823 when the court numbered only 6. And then the next year was our 10th anniversary, so the spouses had another party for us. We do little things like when it's a justice's birthday, the chief buys some wine and we precede lunch with a happy birthday toast and a chorus that's led by Justice Scalia, because he's the only one who can carry a tune. And sometimes Marty bakes a cake that we have at these birthdays. 2 of Justice Scalia's daughters had wedding receptions at the court, as did Justice Kennedy for his daughter. And my granddaughter's 3rd birthday was held, that celebration, at the court. The only time that the featured item on the buffet table was peanut butter and jelly sandwiches. So, and we all genuinely care about each other. I can tell you that right now, how much all of us care about our chief, the genuine affection we have for him, and the support that I had from my colleagues when I had my bout with colorectal cancer. It just helped you through a very difficult time. But we are almost like a family in that respect. Now, you said something about opinions that can be rather sharp, but I hope you've noticed that at least 2 of the justices, I'd say 3, do not engage in that kind of rhetoric.
You're one of them.
Yes, and Justice O'Connor is another, and Justice Souter.
Interesting. And it's a good tone, because you certainly make your constitutional or statutory differences known, but without a personal edge.
No, because I think it's just distracting. And sometimes I'll tell a colleague, you'd be ever so much more effective if you took out those ad hominem remarks.
But he doesn't listen.
Sometimes
Sometimes he does. I wonder sometimes the extent to which the court operates as 9 separate law offices that each come up with a position and you sum them up, or to what extent you reach decisions collectively. And I'm trying to what extent do you try to sometimes bend your views in order to make more of a court as compared with having 9 people do dissenting and concurring and separate opinions? To what extent do you think a justice should accommodate his or her views to reach a consensus?
it isn't so much a question of switching sides in order to have a clear majority. It's taking what would be your alternate position. Mm-hmm. Let's say you have an idea that this case should be a major headline case, should rule squarely on an issue that will cover the waterfront. But there's a fallback position that will decide this case the right way, leaving many questions open. That kind of, you can call it a compromise or accommodation, is not unusual on the court. And I think it's more common now that we decide somewhere between 70 to 90 cases a year than it was when the court was deciding 140 cases. The process couldn't operate when there were so many cases to decide that had to be churned out. But with more time, there is the possibility to persuade, to rethink your own position, and to make adjustments that will bring us together. So I hope the law teachers appreciate that there are fewer decisions nowadays that say, Justice so-and-so announced the judgment of the court, and an opinion in which Justices A, B, and C join Part 2B, and Justices D and E join 3F. There's less of that nowadays. And we do reach tentative decisions pretty soon after the argument at our conference. But the collegial process goes on, and it can be in memos between chambers, it can be phone calls, it can be you go to a colleague's chambers, perhaps with another colleague, and talk about this hard issue.
Everybody is comfortable in your court with, after the court is conferenced and reached a tentative decision of groups of justices, 2 or 3, or conferring among themselves. I ask that because Justice White in 1968, when our clerk sent around a memo saying that he thought it inappropriate for justices to confer about a case which had been submitted for decision except by memo to the opinion writer assignee with copies to the other justices. And then Justice Black would sometimes say that in a particular case he suspected there was some sneaking around the halls going on among some of the justices. And so there was tension over that. But you all are comfortable meeting with some people meeting in subgroups to talk over the case?
But for the most part, the communication is, as you said, by I call them Dear John letters, because we use only first names in our internal correspondence. So you'll say, Dear John, if you're responding to Justice Stevens, and you send copies to the conference. But sometimes, let's say you're trying to get together on one dissent instead of 4. You will be dealing with that group, not with the court as a whole. Or very often a colleague will say, I sign on to your opinion, that's the part that goes to everyone. And then make suggestions, not of substance, but of form of expression just to you, and say, this is not a condition of my joining your opinion, but don't you think it would be better to use this word rather than that word, or take out that citation?
How do you, and this may be an impossible question to answer, how do you go about deciding cases that are hard cases for you? You stare at the wall? Do you reread stuff? Do you talk to clerks? Do you talk to colleagues? What do you do with the really hard cases?
All of the above, but most of all, I immerse myself in the case. And sometimes you feel that you're in the woods and you don't see a way out. The only way you can get out is by continuing to read on, read back, and then one day you begin to see a clearing. And I had that experience just last night. That's why I'm so upbeat today. Because I, in a very difficult opinion, and I can't tell you which it was, I saw that clearing, but it took, I don't know how many days of being in the woods. But you can't just say, you just say, I know, because we've been through this again and again, that the light will shine. But in the meantime, what I must do is just read everything I can.
Do you sometimes change your mind during the deliberative process after you've taken a tentative vote in conference?
Yes. No, this is not usual, but every term that I've been on the court, there has been at least one decision where the court changed. what started out as 5-4 one way is 5-4 the other way. The most exhilarating experience I have had to date is to watch a dissent for 2 people become an opinion of the court for 7.
Wow. That's really quite. I looked through the files one rainy Sunday with Justice Black's permission, and was astounded to see the cases that I think of as landmark cases that had what I always knew as the dissenting opinion and draft as the opinion of the court, and watched the process of persuasion. But I've never seen a case go from 2 votes to 7 in the process. That's good legal argumentation. Well, someday you'll be sure you write that up for the 25-year sealed up thing, so we can do it. When you look back on, let me ask you about the process of decision making. What do you, because we've got law students here, what do you think makes for good advocacy in briefs and an oral argument? And you, of course, have more experience arguing cases than any of your colleagues on this particular court. What strikes you now on the other side of the bench as effective advocacy?
I'd put number 1, an honest count. Because if you slant the brief, if you try to hide a bump, the court, which is very well prepared for argument, will most likely find that out and then not trust the rest of what you say. So a brief should be first and foremost reliable. When the justice or law clerk goes to check this case that was cited as a leading precedent, it must say what you say it says. Because if you're slanting it, the court will not trust you. Now, as turning to the oral argument, the most important thing is to be conversational with the court. The court is not a place for speech making. There's a precious half hour aside, and the exercise is a dialogue between counsel and the court. If you try to give a prepared speech, you will surely be interrupted. And I know that many lawyers resent the number of questions that we ask. But what is the purpose of oral argument? It's the lawyer's last attempt to persuade the court of the rightness and justness of the lawyer's position. So the lawyer must be prepared to answer the questions that are troubling the justices. So lawyers should welcome questions. They should use them sometimes as a springboard to get into something else that they want to say, but being supple is tremendously important. And it doesn't do, I think, I've watched lawyers who are trained to say no, as whenever a judge asks a question, their first answer is no, and then the others whose first answer is always yes. But the idea that oral argument at its best is a conversation between learned counsel and what we call a hot bench, that is, and something else that lawyers should be alert to. The first thing that I read when I'm preparing for a case is not the lawyer's brief. It's always the opinion below, the opinion that we're reviewing. So then I know when I turn to the brief what the lower court said, and I then can check whether the brief is fairly representing the decision that we're asked to review.
What do you look for in a law clerk when you're hiring? Is there some, what is that? You get so many wonderful applications. I wonder how you go about choosing.
Well, they all have sterling resumes. The writing sample is very important. Now, because we get just hundreds and hundreds of applications, I can't read the samples myself. I rely on recommendations, nowadays mostly from the judges. Of course, professors can give me good advice. But now I'm taking people who have had a clerkship with another judge, because if that judge will tell me this person was super. Writing ability is very important. And then what I call chemistry. Our chambers are rather small. We have 2 secretaries, a chamber's aide, and the 4 law clerks. So it must be someone who is what the French call sympathique, who cares about other people, is sensitive to the most important people to me in my chambers, my secretaries who have been with me from the days that I was on the DC circuit. And some law clerks tend to be a little bit on the arrogant side and don't appreciate.
Don't tell me that.
You know,
don't appreciate the role of the secretaries
Yes.
who've worked with you. When I do my hiring, I think works well with others is a very important criteria
Yes.
that you're looking for in a young lawyer. You're a hero to many people. Ann and I have been to the Women's Museum at Seneca Falls, New York, where you are already an important part of the exhibits and will be more so for many generations to come. You're a hero to so many. Do you have heroes?
Do I have heroes? Some people ask me that question about when I was growing up, who were my role models? Well, women weren't on the bench and they weren't at the bar, so my hero was Nancy Drew, because she was a girl. She went out and did things. And,
That's a good hero.
thinking about people I encountered years later, one I never met, but if the first woman who served on a federal appellate bench was Florence Allen, appointed by Roosevelt in 1934. And what she encountered, she's on the Court of Appeals for the Sixth Circuit, and all of her brethren go to lunch at a certain club that excludes women. And they never think that perhaps she will feel left out. Well, there is a Florence Allen hot plate in the court, and it gets passed. It went first to Cornelia Kennedy, and now it's in the chambers of Sissy Daughtry to remember what it was like. Now, in the DC circuit, the first woman who was ever appointed to a federal district court, federal trial court, served there, Bernita Shelton Matthews. She was appointed by Truman in 1948. And she was, in her younger days, counsel to the National Woman's Party. Mm-hmm. This was the radical wing of the suffrage movement, the women who said, the vote isn't good enough, we want an Equal Rights Amendment, and introduced the Equal Rights Amendment in 1923 and every year after. Well, this woman was in her 90s by the time I got to the DC circuit, but she had some wonderful stories. I was so lucky to be able to meet her and to hear some of the tales about. She was going to law school at night at the time of the suffrage movement. And she would spend her weekends picketing the White House and carrying her little sign, votes for women. But she said the way she managed it is if anybody asked her anything, she just stood her ground and didn't answer. Because she said if she talked, she might be arrested for disturbing the peace. And she didn't want to risk this law degree that she was hoping to get. So she just held her sign and let the words speak for themselves, votes for women.
I know you're a great opera buff. If you could have been a diva, would you have chosen that career instead of the one you've had?
I still have that dream every day.
It's not too late. Ladies and gentlemen, let's thank Justice Ginsburg. Thank you very much.
Thank you. The Justice has agreed to take a few questions. I want to mention first, I know many of you know that Professor Neil Siegel, who's new with us this year, was the clerk last year for Justice Ginsburg and talks often of how much that experience influenced him. I'm not sure whether Neil has been able to make a Blue Devil out of Justice Ginsburg, but I know he's been working on it and been piling Blue Devil paraphernalia on her desk for some time. So we can take a couple of questions. Obviously, there are some questions you might ask which Justice Ginsburg would not be allowed to answer, but keeping self-censoring in that way, are there any questions you'd like to ask before the reception?
I'll repeat them for our at-home audience on C-SPAN. So, any questions? Yes, ma'am.
I was just curious, Justice Ginsburg, if you had any specific advice for women at the nascent stages of their legal career today, now that you've made all of these steps forward for women.
The question is, what advice does the Justice have for women at the nascent stage of their legal careers?
It's a great time to be a woman and a lawyer because the closed door era is over. But I think for a young woman to recognize that if she does nothing more than get a job in the law and do a day's work for a day's pay, she won't be much more than any other kind of craftsperson. If you want to get real satisfaction, do something other than what is your paid work. Whatever community organization, whether it's a women's organization, whether it's fighting for racial justice, for fair treatment to newcomers to our shore, you will get a satisfaction out of doing something to give back to the community that you will never get in any other way. And also, if you think of yourself as a teacher to your colleagues, women have had a major part in changing the atmosphere at some of the places in which they work. And by that I mean flexible hours, much easier nowadays than it was before PCs, when you have a whole law library at your home, literally at your fingertips. Having the firms provide or join with other firms in providing daycare, the kind of humanizing atmosphere that it's a little hard to get law firms to move in that direction, but they are. Well, that would be my advice, and as I said, I think it's really a great time for a woman to be in the law when she is wanted, when women are wanted by the law.
In the back?
Yes, sir.
I was wondering if you could say anything about what has been the most satisfying for you personally, whether as a justice or an advocate throughout your career.
What has been most personally satisfying for Justice Rehnquist, Justice O'Connor? At least it wasn't. What has been the most? I knew I couldn't get through this with doing it, but at least I promoted you to Chief Justice. What has been most satisfying in your career?
Well, it's the satisfaction that you get when you are genuinely able to persuade other minds. I see it now. In the days when I was an advocate, one can see it from Harry Blackman's papers, which you know are available at the Library of Congress. I found out that one of the cases I argued, the Goldfarb against, or Califano against Goldfarb, was a real cliffhanger. It was originally 5-4 the other way, so on the question of whether the court ever changes. And it came out in the end 5-4 my way with 2 flip-flops in between of justices moving from one side to another. But that art of persuasion and having it effective, now often it isn't, but you just have to take that and then go on to the next and give it your all. So it's the process of engaging with another human, and influencing someone else's thinking. I tried to do that as a law teacher, too.
I think we've seen today how. Do you have a question?
So my question for you, Justice Ginsburg, is what did it mean to you personally when Justice O'Connor became the first woman appointed to the Supreme Court? And what are some other firsts, if any, you'd like to see happen in your lifetime?
I was overjoyed when Justice O'Connor was selected, and very glad that President Reagan took that as one of the first things he wanted to accomplish. I was appointed to the bench by Jimmy Carter, who made a tremendous change in the U.S. judiciary. When Carter became president, there was no woman, well, one woman, Shirley Hofstadter, in the entire country on any federal appellate bench. Shirley on the Ninth Circuit. President Carter made her the first Secretary of Education ever. So then there were none. He decided that he wanted to draw on the talent of all of the people of the United States, and not just the usual white males. So he looked at places where people hadn't looked before. And he came up with 11 women that he appointed to courts of appeals and over 25 to district courts, many members of minority groups. And in the fall of 1980, in October, 1 month before the election, when I think the president sensed that he would not be reelected, he had a reception at the White House for all the women he had appointed to the bench. And he said that he hoped, even though he never had a Supreme Court appointment to make, that he would be remembered in history for changing the complexion of the U.S. judiciary, which he did quite literally, and no president ever went back to the way it was. Witness President Reagan, who wanted to go down in history as the first president to appoint a woman to the U.S. Supreme Court.
Thank you, Justice Ginsburg. Dean Bartlett, do you have any?
Just want to invite everyone to the reception outside on the loggia. And once again, Justice Ginsburg, we're so delighted to have you here at Duke. Thank you for coming.